If we 20, you have filed a? Item 20. 22. 20. Huh. So, okay. Mr. K. Mazumdar, will counsel for the petition substitute. It may be given 3 weeks time to file a substitute petition. There's a matter.
May I please? Once order, matter 15 minutes.
1-5.
1-5 minutes. Matter has become infrastructure file.
Okay, right. Mr. B. Raman, I will counsel for the petition. Substitute the matter has become informed. According to the risk prediction is the risk is
Hello.
made in the but like matters for motion. Like,
We filed a content petition on Friday last. The same is not listed. I'm saying so far to be
huh? What?
I can share.
Yes, yes.
That is not a form of petition.
On the prayer made on behalf of the petitioner, person list the matter after the meeting. Okay. 1 night. Yes. Huh? Who has got? Who is Eddie Chaudhary? Huh? Is there a water? Oh, I'm not, but let me see, we'll wait. Just wait, we'll see.
Which is the road? I make the mention.
Yeah.
For listing of a matter for withdrawal lordship tomorrow. Lordship. Thank for following of the report.
Item number
28.
28.
The filing was
Okay. Oh, you filed it when?
Yes, okay.
What is the filing number?
Then I will.
No, you don't know if you have filed. Sometimes we all don't file it. What is the filing number?
We have filed it, lordship.
Filed it.
I will give in writing lordship. The filing number. Down.
Have you read the mention memo? Where's your mention memo?
I am following for the record lordship. That's why
Oh, it doesn't work like that, Mr. Counsel. When you make a mention and you want to call for the record, you have to make a mention memo. There is a mention memo. How long have you been a lawyer?
1 year.
1 year. If senior hasn't told you this,
Yes, lordship. I will do the mention right now.
is it with you?
No, lordship. Right now it's not. I will do it in 2 minutes.
What is the matter? What is the number of the case?
Lordship, you can find the description.
New matter.
Yes.
Okay. No. Wait, no.
See the
Yes. Oh, one day you take it back. You read it, you translate what is. What is it? It's not for you.
No, it's not.
Okay, anyway, leaving that aside, what is your case?
My case is that, since my I have been given the bill for a period of 3 months.
Was it on the basis of any, was it on the, then, where is your case? Okay.
No, the last year settlement process of.
No, and your 3 months is ending on June.
मतलब the Russian locality मतलब down to pace मतलब the 21.
Yes,
These are earlier government notification.
huh?
Case 21.
Yes,
Pursuant to the decision taken in the meeting of the President to bring on front of the government Makam is pleased to cancel the ongoing put to the settlement of the hard fishery formed as a for the year 2024-25.
correct.
Then मतलब reasonable to the pleased to मतलब the issue मतलब notice at the मतलब extension was cancelled.
Correct.
That मतलब so मतलब all the hard and fishery run by the government.
Correct.
Since it is a fishery miller, so there was holding a could not run the fishery. So it was leased for limited period. And in this whole I have been given the lease for a period of 3 months.
How can you be given the lease?
Because miller the
No, we are setting aside that lease. No, you cannot be given a lease
now miller the
on the without a NIT.
it is a fact.
How is a fishery? How is as per the rule? How is the fishery to be settled?
Under the concept that it is miller to tender
Which section?
109.
109
Nine.
of the
Yes.
fishery rule.
No miller.
Panchayat Act 109.
109. Yes, 109.
Page 109.
109.
Yes.
Save as otherwise provided in this act of rule, when thereunder all fisheries of the control contract shall be.
Correct.
By
So that's not. So how can it be settled with you?
Because
Your case is that it has been settled with you.
several portions of my 2024-25
Okay.
was Milota.
And there is a banning of fishing.
No, it is not completely Malota banning Milot.
No. Anyway, right.
There is a Milot, some restrictions.
Third, Mr. Dean,
And I have a Milot before the
Senate counsel for the petition. Will submit that the petitioner has been allowed to run. Has been settled, has been, let me see the word used by.
Just to take it. Then my lease amount Milot to be Milot. That in the budget and the Milot, the huge amount has been Milot invested.
Come to para 9 of your writ petition. Please read.
Because it is like a short tender.
Please read.
That in presence of a short tender, total issued by the being after the petition along with other people.
No. So in persons of short tender notice, where is that short tender notice?
This is the notice board. They have to ask to file application. So it is the fact, Milot. I cannot see there is no tender notice. And it was a notice board that in that who can.
I'm going to ask you, I'm going to impose cost upon you. for bringing false facts before the court.
because no tender. It
There was no tender. Your entire case was that there was no tender issued.
tender
Now,
was not issued. Tender was not issued.
tender was not issued. Then, but short tender notice was issued.
But this it is my fault because
It is your fault.
I have to return as notice. Notice of issue. It was notice of issue.
Notice was issued.
Yes, notice was hang in the notice board and in pursuance of the notice.
Where have you said that it was pasted on the notice board? Where have you said in your pleading?
It was a notice. So
You pay cost.
and
Now you're trying to play around with this court.
and nothing pass order necessary order, but the imposition of your ban, it is not the ban imposed upon the fishery is not a proclaimed fishery.
Whatever it is,
But
whatever you
and it is not a complete restriction.
heard, Mr. J. Kavi,
And the tender
learn it how to
What's it,
follow the dictator. Please keep quiet now. Otherwise, I'm going to take so moto action against you. I'll initiate a contempt against you. Please keep quiet. I've heard you. Heard Mr. J. Kavi, learned counsel for the petition. To submit that the erstwhile Bata, Java, and Tarik Panchayat had issued a notice inviting tender dated 30, bracket NIT shop, dated 35/2024 for settlement of different hearts that fishery under his jurisdiction for the year 2024-2025. That is from 1/7/2024 to 36/2020, including the Dubai Qatar deal, which covered 65 bigas of land. However, all ongoing process of settlement of Hutch/Dutch fishery bond for the year 2025, for which NITs were floated, were cancelled pursuant to notification number ECF 221100 dated 29/6/2024, issued by the Principal Secretary to the Government of Assam from a PNRD department. The notification dated 29/6/2024 was put to challenge in a number of writ petitions, the leading case being WPC number T649 of 2020. Bracket Padma, Kanta, Hagarika, and another versus the state of Assam and others. The WPC number 3649 of 2024, etc., were disposed of by this court by order dated 30/07/2024 by directing the respondent authorities not to extend the period of settlement any further without falling off tender. Further, the authorities were to run and manage the aforesaid market department. The petitioner's counsel complained that as the settlement of fisheries could only be made through a fresh NIT to be issued by the authority. And in the meantime, the authorities were to run the fishery. The being Anchalik Panchayat issued a short tender notice to enable the response, to enable the, to enable, for now, not for settlement of the Dubai Qatar bid for 3 months. From 1/4/2025, 36/2020. Not tender notice. The petitioners of the submit that even though the said fishery trash deal has been settled with the petitioner for a period of 3 months, the petitioner has not been allowed to fish, has not been allowed to fish on account of the notification dated 28/3/25 issued by the government of Assam, fishery department, which has prohibited fishing in the state of Assam from 1/4/25 to 31/7/25, as it is the breeding season for fish. The petitioners found the submit that a direction should be issued to the respondent to cancel. No, there's another order. Then,
In the meantime, the issue can down, the space for the settlement. Without giving me the 45 days time at 2025.
the petitioners found the submit step. In the meantime, the
Liability government side.
Dania Betty Ground Panchayat has issued a tender notice dated 5/6/2024 for settlement of the Dubai Qatar bid for the year 2025 back 26. That is from 1/7/2025 to 30/6/2025. And the tenders are to be the last date of submission of tenders has been fixed on 25/6/2025. The petitioners found the submit that the tender notice dated 5/6/2025 should be set aside as in terms of Section 109 of the Assam Panchayat Act 1994 and Rule 47 of the Assam Panchayat Financial Rules, 2002. All fisheries of an Antarik Panchayat is to be settled by sorting a tender for at least 45 days before the last date of submission of it. However, in the present case, only 20 days time has been given for submission of it. The petition also submits that as that Dubai Qatar bid is not a proclaimed fishery as provided under Rule 1/8 of the Assam Fishery Rule. There cannot be a prohibition in Pakistan. As such, the impugn notification dated 23/8/2025 should be set aside. Mr. AK Ghosh appears on behalf of Mr. Esther. I have heard the word of the petitioner has put a challenge to the NIT dated 5/6/2025 on the ground that the acts and rules have not been followed. In as much as 45 days time is to be given to the tenderer to submit them. The above being said, the act, the, the agreement made by the petitioner, the petitioner, that a short tender notice had been issued by the authorities is not, is a wrong statement, is a wrong agreement made by the petitioner. As the petitioner's counsel has submitted that no short tender notice was issued by the response. Further, Section 109 of the Assam Panchayat Act 1900 provides that settlement of a fishery can only be done by inviting tender. In the present case, no tender has been invited by the authority. And as such, the alleged settlement, temporary settlement of the fishery for 3 months with the petition by the authority lies in the teeth of the order passed by this court in a number of writ petitions, some of the leading case being WPC number 3649 of 2020. Next one. The notification dated 28/3/2025 issued by the Additional Secretary to the Government of the Assam Fisheries Department, State of Bit 40. The above clearly goes to show that the above clearly states, the above notification clearly states that fishing has been banned in the state of Assam in the various fisheries. On account of, with effect from 1/5/2025 to 31/7/2027. Under Rule 23(1) of the Assam Fisheries Rules number 19. Inasmuch as this is the breeding season of chicken and as such, the as such notification aims to ensure natural breeding of propagation and growth of fisheries in all fisheries and natural water bodies. In view of the above, in view of the above, in view of the fact that the temporary settlement of the fishery with the petition is illegal this court is of the view that any settlement that might have been made by the respondents with the petitioner is not sustainable. The the temporary, the alleged temporary settlement of the fishery with the petitioner for 3 months is accordingly set aside. With effect from today. This is according to set aside. Next para. With regard to the contention of the petitioner's counsel that the tender notice dated 5/6/2025 for settlement of the mobile kata fee should be whatever. Last sentence. Should be set aside as 45 days has not been given to the intending bidder to submit their bid. This court directs the respondent authorities to 25 is today. Today. Is directed to is directed to no, this court is directed to ensure that intending bidders are allowed to submit their bid within 45 days from the date of issuance of tender notice dated 5/6/2025. In terms of Rule 47 bracket 2 of the Assam Panchayat Financial Bracket Close Rules, 2002. Where is that? 47 2. Which states that tender notice can be floated for at least 45 days before the last date of the Panchayat Financial. In the present case, as it is not possible to close the tender prior to 45 days of the last financial summer, the respondent should ensure that at 45 days should at least be given for submission of them. That is the thing according. That's accordingly. A corrigendum to be issued by the respondent, extending the last date of submission of the tender. In terms of the, in pursuant to the NIT dated 5/6/2025, till 20/07/2021. That is question accordingly. You next time don't make wrong statement. That is a completely wrong statement. Item?
Item 2.
Yes,
Whether the termination was possible to be the service is being found outside inspector or whether the service
DG set was no longer required.
is no longer required. I mean, like one of my page 28 and still go
Page 28.
page 20.
Yes,
Paragraph 2. In this regard, it is informed that the Corporation of India Regional Office Assam has issued a letter of acceptance work order for the work of supply, exploration, testing, and commissioning of a silent type for ABA that along with the allied civil and electrical work that MCI is under Assam. Now, my lord, the last paragraph, accordingly, considering the revised operational requirement, it has been decided to terminate the aforementioned contract with effect from 2025 in accordance with clause 14 of the general contract provision of the order tender form, which allows for termination in case of services are no longer
correct.
required. Now, my lord, page 70.
70.
Here, the relevant clause 40.
Yes.
Second line, madam. However, the contract is subject to termination at any time if the services are not found satisfactory. Also, FCI can terminate the contract by serving 3 calendar month notice if the service of the contract is not. And here we have given only 1 month. My instruction is that can be treated as a 3 months notice. Madam.
No, it's T1. So basically,
We have given only 1 month. Madam. Time.
so basically, so basically, there are only the two reasons or two grounds on which the contract can be terminated. Correct. One is if uh, if the services are not satisfactory. Number one. So that is not a ground. The second ground, FCI can terminate the contract by serving 3 months calendar notice if the service of DG set is not required. So it is on this ground.
Yes, madam.
It is on this ground.
Yes, madam. The termination letter is itself it is required to be calling the enhanced dialogue.
Correct. So it is not required anymore.
Yes, madam. It's not
It's not required anymore, but you have to give 3 months.
Yes, madam. Here we have given only 3 months, madam. So my instruction is that madam to get 3 months.
Okay.
Service, and except for this, it's clear. That matlab my services are not required, because they have upgraded.
No, so,
Two more items there, here, madam.
no, you see,
Commission.
so it's better if since they're relying upon the second condition, at least they're liable to give you notice. In the first instance, they're not liable to give you, so you'll be happy. When you get 3 months notice. Yes. Okay, right. I'm with MR Adhikari, learning software for the petition. And Mr. VK Singh. B or B? VK Singh. That's what I saw VK Singh. That is Chief of Army Staff. VK Singh, learned counsel for the FCR. Next one. The petitioner's case is that the petitioner's contract was terminated by letter dated 6/6/2025, issued by the FCR without issuing any prior notice. In terms of clause 14 of the general terms and conditions of the NIT dated 23/4/2024. The petitioner's counsel submits that the contract can be terminated by only on two conditions. One is firstly, when the services of the petitioner are not found satisfactory. And secondly, by serving 3 months calendar notice if the service of the DG set is not required. Next paragraph. Mr. BK Singh submit that the petitioner's contract has been terminated by giving him 1 month's notice as much as the service of the present DG set is no longer required and as a higher capacity DG set is being installed by the respondent. He submits that as there has been a Should I not install? It's going to be installed. It's going to be. So, should I make your submission that you will give 3 months notice or do I direct you? I'll direct you. Okay. Next. I have heard the learned counsel for the party. Uh, Clause 14 of the General Terms and Conditions of the NIT, dated 23/4/2024, states as follows. It is in the first order. 14, huh? Good stuff. A perusal of the same clearly goes to show that in the event the service of the DD set is no longer required, the petitioner that contractor would have to be given 3 months prior notice. Good stuff. As the same has not been done in terms of clause 14 of the General Terms and Conditions of the United States. The impugned letter dated 6/6/2025 is not sustainable. The same is accordingly satisfied. However, liberty is given to the respondent to invoke clause 14 of the General Terms and Conditions of the NIT dated 23/4/2024 by strictly following the same in letter and in spirit. That is accordingly disclosed. Right. Like. No. Permission to withdraw. With liberty to make a representation for office. So selection is not done as on date. Selection is not done. Selection is not done. Then? So I am actually seeking a mentor before that I should make a detailed representation. Correct. Okay, right. Mr. K. Talukdar. K. Talukdar, learned counsel for the petitioner. Says that he may be allowed to withdraw the writ petition to enable the petitioner to first file a representation to the authorities with regard to his grievance. Ms. P. Said appears for R.M. Das, learned counsel for the water resource department. The prayer of the petitioner's counsel is allowed. This petition is dismissed as withdrawn, with liberty as free. And you see, Mr. Counsel, you have submitted your application this month only. You want everything like 2-minute noodles. Oh, he's not a country. That's what he said. He's a country.
I think when I feel like it is renewal every year, there's not a next renewal documents, they have not anything. No, their statement I made for the 18 years. A provision says it can be number.
But they never started a business. It's a question of fact.
Existing country retail license. 2019, we were issued like 18-19. Thereafter, nothing has been done. No renewal has been done. Because they're reading for 8 years, I have submitted application. I am reading in this claim. And I have connect the.
You see, your willingness is clear. COVID happened 5 years back.
Yeah.
What did you do after that? 22, 21, 23, 24. What did you do?
22, there was COVID. Then, my lord, what happened?
22, there was no heartbreaking COVID. You all walked in.
He,
What did you do in 23? Did you ask for a?
obviously, my lord,
You didn't do anything. 24, did you do anything? No. 25, did you do anything?
25, my lord, the rule came into effect, not small prayer, my lord. Rule came in effect in 7th of April 2025. I came to know from the superintendent office, my lord, in last week of May. So I committed application and rule one.
But you have missed the, you see, you're not an existing country liquor. license holder.
That is not a rigid concept, my lord.
Huh?
State, but not a rigid concept in my.
Let us see the rule.
The state government can.
Let us see the rule.
55, provide penalty and renew my. Page 55, they annex the new rules. Page 55,
But in the page, yes. Yes,
my lord, rule, your lordship will find, amended rule 614.
yes.
That's serial number 8.
The existing country spirit retail licensing.
May I read, my lord? The existing country spirit retail license.
So are you an existing with spirit retail licensing?
And the, my lord, they earlier holding the license in the premises.
Your earlier license was issued. When the license? Let us see the
License, your lordship will find page 17 on 17. This one they can provide.
Page 7.
Yes,
This has been issued under which rule?
under Assam Excise Act 2000. Page 17.
I know, but which provision, which exact provision?
It's under Act of 2000. And your lordship will find a rule 130. Rule 130.
Where does it say that he has got to renew every year?
Okay, rule 128. Rule 120. 120 and 130. Both. There is no only penalty specific. Another amendment is taken to the point, whereby if the renewal is not being done in 3 years' time, the license goes.
Amendment has been done.
Okay. Rule 130. What the case of it?
Listen. This is amendment of
The amendment, done, in 20 February 2024. But the rule 130 or not? 130.
130.
Some detail of it.
Yes.
The principal rule 130, the 7th line for the constitution mark, provided that if a period of such non-renewal of license extends beyond 3 consecutive years, the license shall be deemed to have expired, and such expired license cannot be eligible for such renewal as provided in this. 2018 and 19 was there. He obtained the license, no shop was open. 20, 21, 22, 23, 24, 25. My lord, the rule 130, my lord says, I have the proof, my lord.
Yes.
It says that, my lord, if the licensee fail to pay, my lord, then that default amount, 50% of cash penalty. You have to pay. That is the only condition. So not that he cannot be issued for any renewal. You have to
But then this 130 has been amended.
I am going to be latest book.
Huh?
And maybe this newly submitted application. And what are the like? Yeah, my lord. After all, my lord, it's a.
Anyway, you see, at the end of the day, one thing is very clear. You are not an existing license holder.
Then you some government under the rule.
No, I can take also. You have come before me.
Yes.
I can take. You see, the rules require. Rule 128 requires you to renew your license every year.
Every year.
And Rule 129 gives the procedure as to how you should apply and whether and how the sanction is to be given. You have not done any.
My lord, there is a clause, my lord, that renewal has to be given by, sanction has to be given by.
Where is their application for renewal?
Earlier I have filed it. In 2020, I have.
Where is that in your petition?
I have an
Where is the application?
submitted application phase 40
40,
5 copy.
40.
Immediately when the copy started.
They are not taking, right?
I submitted my let them take a decision by report. But within 60 days, I have come. That is the thing. Another amendment rule, my lord. I submitted within 60 days, I have come. So they have a legal obligation to whether to consider also.
Mr. Counsel, you are not in a hurry for the last 7 years to renew your license. You filed an application in this month. You want
No.
ready answer status. No, you're not even waiting for something. Right. Alright, Mr. Vibhav. Current counsel for the petition who submit that the petition was granted a country spirit retail of license under license number 02/2018-19. Where is this license?
Phase 17 of it. Type of petition now one.
Where?
Phase 1, annexure 1.
Yes. Hey, what?
Annexure 1. Phase 1.
This is number 2. This is not 1. License number is 2. Huh? That register number is 02, not 01. In your synopsis, you have written 01.
I have given two numbers. Okay.
You write 02/2018-19. You have given two numbers. Why should you get this? Where is the license fee of 2013-14?
That is also there.
Is that your license?
No,
Then why have you, huh?
it is not three. They are three. Combined with them. They have the
Okay.
premises.
Huh?
They have the existing premises of.
Mr. Counsel, these are three different cause of action.
I think they can take a decision matter what.
You withdraw this writ petition, file three writ petition. Then we'll see. You withdraw this writ petition, you file three writ petition. Others are dismissing it. This is multiple causes of action by different persons altogether. No. You you.
Let me take instruction matter.
Okay, right. I'll dismissing it with cost.
Well, I
Right, Mr. B. Huh? Mr. B. person, I'm counsel for the petition, saying that he may be allowed to withdraw the writ petition. With liberty to file a claim. Somebody as much as. Now, with liberty to file a claim by filing three separate writ petitions. As there are three separate writ petitions. Mr. Around appears for the health department. The prayer of the house is pertaining to descriptions because come on with liberty of faith. Cannot do like this. Three different causes of action.
May have the matter taken after something. We can make.
Yes, what has happened there? What has happened?
Yes. What happens is that I'm in safety consultant. That and it's a two.
Okay, we issue notice. We issue notice.
Instruction.
Yes, third, Mister.
Yes, Big Boss.
Yes, they can counsel for the petitioner who submit that the petitioner was empaneled as a road safety consultant by the Ministry of Road Transport and Highways, Government of India, to act as a safety consultant for the design, stage, and safety of users. No, this is Government of India, full stop. However, due to a death that has occurred in the construction site at Baihata, Packet Village 27 on 28 to 2020. The petitioner has been debarred
For 1 year.
for 1 year for participating in Atteda
Yeah.
in other tenders. You notice the tender for 4 weeks. Miss Mrs. Albora, accept notice on behalf of 2, 3, 4, 5, 6. This is for one. This then does appear on behalf of the SPMAD CGC. Correspond number 1. Petitioner takes death for service of notice on the respondent number 7. By registered court is ready within 2 days. This is the matter of the police. Please give a date.
The meantime, in order, operation plan, in order.
We'll see on that day. In the,
And we be allowed to file application. Application of application will be taken.
then you can file, no problem.
No, that's what the,
No, we will say that on 26, 7, 24/7. The prayer for interim order may be done.
Not like.
No.
I have to.
Huh?
My application in the other future projects, really allowed. Breaking it.
No, not so fast.
Okay.
What is this settlement of?
Deal with.
Yes, what is the case, Mr. Datta?
My lord, actually, petitioner doesn't have any legal right. Because as per the Panchayat Act, only 1 year can be given by. Every year we have to settle, my lord, by through NIT. At that time, NIT was not there. Therefore, he may be, my lord, settled, my lord. Now they are claiming that they have deposited for 3 years, which is not legal. Illegally, if they have made any lease or agreement with our officer, that will
That cannot be done. Yeah. Yes,
What I want to visit is, I was sitting for 3 years.
let us see the settlement order.
Here, and the vernacular is that hey,
Is this settlement on the basis of some NIT?
procedure.
Huh? Is there any NIT?
NIT have the procedure.
Where is the NIT?
No, NIT you have not had. But what they are doing, Bala, because there is a delimitation for the state of Assam. Some town panchayat has been placed to some other area. Now this same place, because of this delimitation, they have now the new town panchayat has issued a test tender. That, Bala, this page here you will also find it is a Korea Hawaii Mari bill.
No, where is the settlement? Where is the NIT? Is it on the basis of NIT? Show me the NIT.
Bala,
Can they?
No, tell me one thing, how are fisheries settled in by the
For the provision of 101.
109? 109 requires NIT to be issued.
Well,
Now,
I've got.
so let us see if there.
Maybe read mine. Page 12.
Hmm.
In the proof.
Uh,
Why not read it, madam?
Yes.
It is hereby informed you that the standing committee of Gudia Anchalik Panchayat in its meeting dated so
Has decided to accept your
accept your application for settlement. The lease of the bill at the value of 12. Due to withdraw of the application of the earlier lease.
Withdraw earlier, let's say, it has been. But every input order should specify something in that particular order. Why it is valid? There's nowhere it has been stated in the first tender process. Nowhere it has been stated because for
Where is your averment that you have done it through some NIT? You have been settling on the basis of
Lease
NIT.
out and settle with the para two. Set out this, but they have not said anything. Now coming out.
It is your petition, how can they say anything?
But Lord, I am not on that issue. The impute order, what they have placed by a fresh tender process. Now they have issued a fresh tender process. Was it permissible?
There's no shout, there's no need to shout.
But I am not shouting.
They only,
are placing all different fact against the law.
I want that the initial, if everything is correct, then you have got a right. If you don't have, if the initial settlement is not as per law, then how can you?
Has they cancelled by the tender process? Has they cancelled by illegally? Without cancelling?
Where is the tender process?
Well, they are saying it is illegal. Whether they have cancelled, why they have allowed me to run for this year? They were sleeping.
I do not know, some officer has been doing some illegal act probably.
Well,
Or
not
some,
illegal act. I have
Anchalik Panchayat.
representation. At least that representation will be disposed of. So because of the delimitation they have done it. Now the Gaon Panchayat has been settled by a different, different Gaon Panchayat. This tender process has been issued by a different Gaon Panchayat. You also will find the impugn order that is at page 19, the vernacular is page 20. Only because Mala, they come and say something before the court without any document. That cannot be taken as a gospel truth.
No, I'm not on that. I'm on only one point. If your settlement has been done validly, correctly as per law,
Mala.
there's no
If
reason.
it is not done, then you have to pass that order.
No, you, it's you, Mr. Counsel, it is you who has come.
But I
It
have
is,
come.
so, sir, that is why this court has asked you.
Mala.
This court has asked you a simple question. Whether your settlement was done on the basis of some NIT that you took part in.
This particular fishery.
You're not answering that.
But I'm facing, but I can't say yes and no, because I have to place the fact. It was settled by a tender person to somebody, and that person has withdrawn his settlement. So it was settled with me.
Were you a tenderer in that NIT?
Well, that has record has to be put before the court by them, my lord.
Okay, right.
Well, section 108 is specifically by saying, well, only for 1 year. Not legal.
But they have allowed me to run for 2 years, man.
Illegal.
Be happy. We have got extra year.
Extra year.
And my lord, they have received the whole
109.
years money.
That you take care, I do not know.
Page 15, you'll also will find, they have received the total amount by us.
Section 109.
Yes.
For only 1 year, Panchayat year, no? Which is 1st July to 30th June. And our
109.
diesel bells as well is also there.
109.
Yes.
Yes,
Now is the
right. Heard Mr. Speaker, right, for the process for the petition. To submit.
Only can I be secure by his presentation. That part, as per law.
The law is there, what you want it as per law,
Because.
I will reflect the law. Whatever. Huh? Sure. Mr. Speaker, right, the process for the petition. Submit. That the jury Anchalik Panchayat, while order dated 26/9/2023, had settled that leased out Boria Kawai Maripit with the petitioner for rupees 81,000 for the period 2023-24, 2024-25, and 2025-20, that is up to 30/06/20. The the petitioner has thereafter deposited the entire his money and has been operating the fishery for the last 2 years. The the petitioner charges submit that despite the settlement of the fishery not having expired, the Palik Kotia Town Panchayat has invited tender for settlement of the Borea Kawai Maripit by the impugned NIT dated 5/6/2025. He submits that as the settlement period up to 30/06/2026, which is 4 days away.
26 minutes.
Oh,
What?
26,
1 year left.
30/06/2026 has not, whatever I said, has not expired. Has not expired. The issue notice dated 5/6/2025 should be satisfied. Mr. S. Datta, appearing for the Panchayat PNRD department, submit that the settlement of the fishery with the petitioner is in violation of section 109 of the Assam Panchayat Act, 1994. Hereinafter referred to as well.
And also without.
So we further submit that the settlement of the fishery has not been done pursuant to any NIT. And it and beyond the period of 1 year permissible. One panchayat, permissible under the act. I have heard the learned counsel for it. A perusal of the settlement order dated 26/9/2023 shows that the Juria and Charit Panchayat had accepted the petitioner's application for settlement of the pickets. To a query put to the petitioner's counsel as to whether the settlement had been done on the basis of any NIT, the respondent, the petitioner's counsel has not been able to show, has not been able to show that the settlement has been done on the basis of any NIT. It is also not the case of the petitioner that he was a tenderer in respect of any NIT for for which he was settled with the said people. Next up. Section 109 of the Act provides that a fishery can be settled for a period not exceeding one panchayat financially, and that too by inviting tenders. In the present case, not only has there been no NIT been issued prior to the settlement of the fishery with the petitioner, but the settlement of the fishery has been done beyond the prescribed period of the Act. In view of the above, this court does not find any merit in the writ petition. The writ petition accordingly dismissed.
Well, liberty will be granted to for a recovery of the matter, this money as well as matter.
That is always there, we can.
Already, yes, if I not react several last.
You can go, you can go. That is not the case. You go. You have entered through the back door, you do things through the back door.
I love that.
I think the Fishery is supplying big the oil India from that time. One week was already operating and another week was dying idle. For that one letter of award was issued on 12/3/20. Well, there was some delay in mobilization, my lord, because the had the, well, the, that week was, my lord, they imported from Japan, and the losses stands to pay 43, my lord. That the supplier has, my lord, the mail, my lord, the TTS number 12 of top right system, ready for export the next 10 days are awaiting equipment booking from Samsung, which is disrupted currently due to Japan try to transfer expenses. So, only for this reason, my lord, there was some delay, and ultimately, my lord, they issued a notice, my lord, if the notice comes to 852. It says, when a notice they issue, the termination notice, but that permitted, the losses may come to page 54 of the page. So even at fixed time, my lord, can be page 50. Yes, page 54, my lord. Paragraph 7 is. In the light of the above, you are requested to take necessary immediate effective steps to complete the mobilization in all respects. Within 25, if mobilization is completed in the depth, you will be allowed to continue with the actual execution of the contract, but applicable LD will be imposed against delay mobilization as per the contract term. So that the under effect LD will be. This is the dimension of in case you failure to complete the mobilization within the timeline. So in case of such failure, your part is contract to your company. So, my lord, this notice will be issued. Then, my lord, there was the inspection on 19th of our week. Then they issued another letter on 20th, next page. With in view of the university they mobilized the Congress of people issued against the subject matter giving a deadline for me to however, as per your inspection for oil carried out inspection 19,525 after the performed as per the contract. Now, I can email to you have submitted high timeline confirming complete operation on 26/5/25 point out by oil during execution. Now, based on your commitment and consider the progress of mobilization as on that, oil management has extended the timeline for completion of the mobilization indicated in the balance note from 25/25 to 26/5. They note that this is the final extension of the deadline for completion of the mobilization in August. To be paid to complete the mobilization in August, 26/5/25, the contract will still start. So this is the notice, my lord. We have completed in 4 days, my lord, and they have supplied the feed, my lord. That I have mentioned in the paragraph, my lord. I did not have copy of the demand at the time. That paragraph 10, my lord. Paragraph 10, if you also see the picture. I have now.
Why is that not part of your repetition?
Time, my lord, but who has made a statement?
Have you given a copy to him?
Yes, I am giving. I am giving. But statement is there. That is the peat mallet is supplied by the oil mallet. Peat for the purpose of mallet cooking. That peat they have supplied mallet on 24th. Because it is complete mallet.
What is this? What is this document?
This is Salan mallet.
For what?
For supply of the peat mallet.
Supply of the?
Peat. One peat. Out of white sick here.
Huh?
One peat mallet is this. Peat.
To pass through oil check. What is this? What for what?
One.
For entire the oil, they had
Yes,
pass.
a pass.
Only this.
This is the pass.
As per that is they can beat, my lord. They have given a beat, there are 10, you know, 50. There are 10, the Krishna extended on 26 May, the mobilization of the thing will complete, the principal was taking for comment.
I think best let us go to the next page, page 56.
Yes. Page. That is the matter. Now, when that it was complete, we wanted to, my lord, cutting of the march, my lord, on that day. They said to wait. Then this letter had been issued. My lord, mention against contract number 22, to the first or letter number 22, the mobilization of status of the rig inspected by us on 25/5/25. In this connection, the following rig equipment you would like to submit them to. My lord, this thing. As per TPI report, it is going to submitted by you against the tender number 22 against who is the subject contract was awarded. The above mentioned equipment was typically inspected by the TPI agency on 22 at Papua. However, it seems that equipment mentioned were actually operating under the contract number 22 during that particular period. Thus, the information provided by you in the same TPI report submitted against the tender number 22 does not align with the actual practical status of the equipment at the time of submission of the bid and actually incorrect. Considering the appropriate tax so oil is now considered opinion that to allow the commercial operation accordingly, completion of mobilization of a rig is kept in a base till further. So, in view of the above, we are advised to clarify the same on the above discrepancy committee, the same equipment against the one tender when the equipment is under obligation of another contract, which appears to be wrong and false. So they are saying this is not a correct, my lord.
I don't know,
No,
this is a
I'm-
question of fact.
I am coming, my lord. That is, my lord, that we have replied to this. We have replied to this. If you also.
No, you see, first of all, let us go to the NIT.
Yes.
Where, with regard to this TPI. What is, with regard to this drilling rig, what is required? What is required? Huh?
Page 20.
Page 20.
They had, should the NIT first type the first of my lord? The
You have applied for one. Yes, let us see what is the requirement regarding the documents regarding this rig.
international competition bid model for expense rental for charter hire of high number of 2000 HP dealing big patents. There is no one of the nothing with that one that this should be in that position or
I do not know because they said out here in your page 56.
Yeah.
It seems they said that the information provided by you in the said PPI report
Yeah.
does not align with the actual practical status.
But
So what is the, you have to give a TPI report.
no, TPS, but as part of tender it is not there, no? But we say that our one thing is lying there.
What is the TPI full form?
Third party insurance. Now, if you come to base $60, because our another rig is working there, okay?
You have got another rig in some other place.
For oil itself.
And you have got in Dimasa Asa also one.
So, well, that is for oil.
But you have taken three parts from that other thing to the Dimasa.
We have informed them, my lord. That is if they are, if you local see, my lord, we have informed them. That,
So you have got an incomplete drilling rig,
base 76, my lord.
which is unusable.
Base 76. No. These parts are replaced, my lord.
Parts were replaced.
Yeah.
And then, so the Dimasa, the Dimasa drilling rig will be brought here. Or that
No.
that incomplete rig will be brought here.
Another rig that is working.
Ah.
These parts were necessary there. At the time, my lord, this mobilization was going on. Your losses may see, that is in March 23, page 76. Page 76, your lordship. This was already, my lord, we have taken the approval for that, my lord. With reference to observation made by all inspector bid, items mentioned in the address file apart from that we have quoted the bid, we accept the fact that mentioned here.
The items mentioned in the attached file differ from what we have quoted in the bid. It differs. Okay.
No, but replace these items with the better model as a person that are remote site amount to paid out more smoothly. We refer that as file for item.
And we replace these items. Okay.
And acceptance treatment. All the relevant certificates are attached to it. So we have replaced fellow. At the time of mobilization, everything is there. And that is why we have given a shock as well. Now, when they have asked for mobilization, we have mobilized it. And after mobilization is complete, they have gone by the time they wanted to terminate for another ground. So arbitrary. And that what so far is there at page 57. So far, you can also see that 57. Regarding this fellow, you can also see fellow page 58, second paragraph.
In course of operations. Perfect. In course of
The three items.
Hello? Yes. Rig package and Bima also, three items mentioned in the letter were deployed out of the idle rig at Patwamura on or about 17 March 23, my lord. How they can now bring it, my lord? We have already brought this.
So which rig are you going to use?
My lord?
Which rig are you going to use in your present contract?
No, we have brought new, my lord.
No, no, no. You have not
We
brought.
have to supply that rig only.
No, no, correct, correct. You have to supply the rig, but a completed rig.
What the rig?
Now you have got two rigs.
Yes.
One is in Dima Hasao.
Yes.
And one is in this place called Batwa,
Yes.
Moran. Now in this Batwa Moran, the Batwa Moran rig is now incomplete because three parts have taken out of there and put it in the Dima Hasao.
My lord.
Whatever.
Yes. Now.
Now my question is,
Yes.
for the contract that you have been awarded now, which rig are you going to use? Are you going to use the Batwa Moran rig? Batwa Moran rig.
Well, Patwamaran and 25.
Now let us see the report which you gave to the authorities. Which rig did you say you will use?
Yes. Yes, 60. This one. This one. Yes. Yes, 60. 62, my lord. Page 62, the last line, mother. Item visually verified, place survey by All India. The place site. Well, the site is the demand. Demand.
So you are going to use the Dima Hasao rig, not the
No.
Batwa Moran.
No. Mother, it, mother, they found it in Patwamaran. Say 60 mother, we have to say. Inspection location is Patwamaran. Say 60. Say 60 mother, inspection location is Patwamaran. In 23 support, we have taken from only 8% of the Malawi. How it will affect Malawi? We are allowed to Malawi to complete the mobilization.
If you take
Yes.
a car
Yes.
and you take out 8% of the machinery of the car, I don't think it will function.
No, I'm asking Malawi when I have to complete the mobilization. If mobilization at the time of mobilization.
Okay, anyway, let us hear.
One aspect I'm submitting, Malawi, whether we have completed the mobilization on 26th or not, Malawi. Because they have given a timeline, Malawi. So if 26th mobilization is complete, we are ready for starting of the March, then how they can go for another aspect of the matter? Yeah, absolutely arbitrary, my lord.
So is the rig already there in the work site?
Yes, it's already complete.
No. Is it there in the work site? Your oil rig, your drilling rig,
Yes.
is it there in the work site?
Website.
Let us ask.
Yes, and now they have
Let us-
asked
let the-
him to vacate it.
Let us ask him.
Well,
Let him give it.
Yeah.
So, is the drilling rig there in the work site?
yes. No.
Is it not there?
I'm submitting. But, that's it. Apart from people raising the mechanism, locally, can it come to care to sorry. Okay. So that for is everything topic.
Huh?
Moreover, topic,
Just a minute. Para 14. Yes.
moreover, keep line.
Yes.
The report dated 24 July 2023, submitted by the petitioner prior to the submission of the plea, clearly states that the equipment had been inspected at Joshua and Dimahata. Actually, there was no submission of misstating and or incorrect statement by the petitioner. From the documents, so that both the site was inspected by the third party. Because third party report is in terms of the contract. But if the contract was whole contract was not added. That's why.
Yes, I noticed that it's not there. That's not very thin.
Okay, we can come to page 30, can I page 30?
32.
What?
Yes,
30. 2.315.
yes.
It's another please. 2. Rates older than 15 years may also be offered, subject to submission of documentary proof as mentioned under clause number 23.44, above provided the offer dealing league has undergone because the upgradation not earlier than 5 years prior to the date of issue of PPI report. The PPI certificate should not should submit PPI certificate in original from any of the below mentioned inspection agency as per Form 1 of the tender document along with techno-commercial and private. So, second number, that narco, where it has, that has submitted the PPI report. The petitioner has annexed the PPI.
Where?
Page, start from page 60.
Page 16 of this.
Report. So, third party inspection report, as per the NIT also, and that was carried out by the business for the petitioner also. Page 60.
1660. Yes,
Also, inspection location.
yeah.
Implex International Limited to Patua Mall. Inspection start date, inspection end date. Now let's look at,
The inspection report.
Yes.
No. Particulars of project. This one.
yes, sir. Page 60.
Re-inspection for Oil India Limited, Oil Termination.
Yeah, thereafter,
Simplex.
inspection location,
Inspection location. Where is it?
inspection details. That's what we'll do.
Where is the inspection location?
Uh,
Here. Patwa Mora.
Yes, Patua. Now, page, can you come to page 63? Page 63. Point number 4. Current location of the rig detail address. The rig is idle condition with base office address, Implex International Limited, Twenso Burua Company Road, Twenso, Assam. Current location, Twenso, Patua Moran.
Patwa Mora. Yeah.
So there is no mention about the demand.
Dima Saab is not there.
No.
Correct.
So this paragraph 14 as well as the reply. After that, clearing some page 56, okay, the reply was given. Wherein also they have interpreted that same page 58. Page 58. After the purpose was issued, they have replied from start from page 57.
Yes. 57.
Yes.
Yes.
And 58.
Yes.
In the course of the operation of the drilling rig case at Hima, the 3 items mentioned in your instant letter were deployed out of the idle rig at
Patua Mora.
on or before about 7 in March 2020. But tender was issued in the month May.
May 23.
Yes. So,
So it's-
just now record of page 77, that was May, March. The
May
tender was issued May. So inspection report is regarding May. We have to that date of
So inspect, no, NIT is May 23.
May 1.
May 23. And so 6 months prior to that, he should have everything in order.
23/5/2020.
23.5.
70 under due intimation of oil India. This was done as the existing items at Lima Hasta were in need of
Urgent repair. There has to
and
be
have
immediate.
immediately replaced. In fact, the TPI report dated
24 July.
the
That's
referred
after.
in your letter also mentioned items physically verified and case certificate at Messrs Oil India, which is the Lima Hasta. But this is also wrong. Messrs Simplex site, which is Patua, and you will kindly appreciate that there is no instance and mixed treatment. The state reports also mention the fact that Messrs Simplex to provide preparation to assurance that the equipment required as per the tender documents will be made in operation and the intake with operation for smooth order. So in this also report also, they have mentioned about the demand. The tender, apart from the base certificate also is to block, third party certificate also in the month of July. Now, regarding the conduct of the petition, They have delayed the mobilization. It is admitted.
Correct, they have asked for the time.
Second lawsuit, we have invoked the clause 41.0, case 37. Whether we can invoke the clause 37 for termination of contract. It's case 37.
Yes.
The information and documents furnished by the bidder contractor in respect of
Where?
41.0 last
41.0. Yes,
earlier supposed notice was issued in respect of clause 44.5 because the delay in tender mobilization was there. But subsequently, since this on inspection, this is inspection that therefore we have raised notice. And by seeing the support, the information and document furnished by the bidder contractor in respect of tender contract are accepted by PBQ and the. However, if it is comes to the notice of the company anytime either during the pendency of the tender or after award of the contract or after completion of the contract, that a bidder contractor furnished fraudulent document, false information in relation to the subject in the contract or committed any misconduct, appropriate action shall be taken against the bidder contractor or for debarment, banning of the bidder contractor from participating in any future tender of the company in terms of company banning policy. Besides, contractor liable for other penalties, including termination of the ongoing contract at his her risk and pay. In such event, the performance security of the ongoing contract shall be forfeited. So, termination is here. Yes. And nothing, yes, arbitration clause, is 37.
37A.
That amount of arbitration.
42.1.
And there is an exclusion also of 42.5.
42.5.
Parties agree that following matters shall not be referred to conciliation or arbitration. Termination is not there. So termination will come under 42.40. Exclusion of parties agree that following matters shall not be referred to conciliation. These are the any claim, difference, or dispute relating to, connected with, or arising out of void decision to initiate any proceeding for suspension or debarment or pending or decision to suspend or to ban or to debar business dealing with the bidder contractor and or with the other person involved for connected. So, regarding this contract is determinable contract.
No, I don't know.
And already there are some marks.
How much are you giving me? See, I've already got 2 here.
First two are determined to protect us. One from our high court, I believe the 15 court. And one for arbitration. 2015, 7, 14. It's, okay, 14.
Yes,
There are 50.
55.
2015.
Yes.
There are 50. Law in this aspect and developed to taking of judgment of dispute and from the reading of the judgment, we follow that the new contractual method to extraordinary remedy of under
Article 226 or Article 32 of the Constitution cannot be invoked. However, in a limit, express or remedies are available only if the non-government contracting party is able to demonstrate that it is a public law remedy which such party to invoke in a contradiction to private law remedy in case they are under the conflict. Some of the case law to which on this federal principle is taken note of here. But can we use
59.
the position of summarize in the efforts of principle has to be understood in the context of discussion. The precedent which we have pointed out above, as far as no doubt there is no absolute part to the maintenance of rights, even in contextual matters or where there are institution of fact, or even when monetary claim is. At the same time, discussion lies with the High Court, which under certain circumstances it can be used to exercise it. Also follows that under the following circumstances, normally the court would not accept such a decision. 69.1. The court may not implement the issue unless the action has some public law character. Whenever a particular mode of settlement of dispute is provided in a context, the High Court would refuse to exercise discretion under the Article 626 of the Constitution and delegate the party to the state mode of settlement, particularly when settlement of dispute is to be resorted to put out
Okay. And this out here, and this,
for determining
okay,
given the paragraph. 1991, 1 is 535.
yes. Sarah,
There are 8, 9, 11, 12, and 14. Apart from our method. Apart from the maintainability issue, what's it committing the fraud to oil India Limited, or to India's state person also the people from some with paid. There are 14.
Yes,
My lord, your office may see the inspection was done at both places, page 62. At the inspection, my lord,
I think you should go for arbitration.
no, my lord, I'm coming, my lord. I can place the judgment, that is judgment also. My lord, if you office see page 62, my lord. Page 62. This is the inspection, my lord. Page 62, last part one sentence, my lord. This is in July inspection. Items physically verified and test have been reviewed at Messrs. Oil India and Simplex site. Oil India site is the Bandar Dima House, Simplex site is the bottom order. Both places, man. It's not that man at one place they have inspected. So, both these two inspected, man. What my I've been saying that only bottom one is not the correct, man. Both places have been inspected. Now you are allowing me to complete the mobilization on 20th May 25. Then you have given 6 days time. Then you have applied the week. And therefore 26 to when the mobilization is complete, then why you have site check? Is it not an arbitrary matter? I should place the judgment of the it is judgment of Supreme Court 21, 16, and 16 days 35 matter. Now they have taken a different ground. Earlier, when termination notice was issued on the ground of non-mobilization manner. Now, when mobilization complete manner, he wanted to terminate me. Huh? The lost this manner too. We have taken another ground, my lord. See how they are affected, my lord, by this. Because they, in July, my lord, they after this, they took both the places.
the TPI certificate should not be older than 6 months as on date of original bid closing. Where is the TPI certificate?
This is a third party comparator, I had, मतलब, basic. Page 60 मतलब, page 60. That was the inspection of climate. They have inspected both the places, man. And what review manner they have given? Review manner they state manner.
No, no, but you see, at the time of closing of bid,
Yes.
along with your bid documents, you have got to submit this TPI report.
Yes.
Then, when was the last date of submission of bid?
April. The bid closing date is manner 4/7/20.
4/7. On 4/7/23.
Yes. On 4/7 manner
And your TPI report, here is what date?
4/7.
The TPI report is 4/7. TPI report 4/7. And as per this clause,
Yes.
the TPI certificate should be older than 6 months. As on the date of original bid closing. So, if it was 4/7/23,
Yes.
yours should have been 4/1/23. Your TPI report. It could not have been same day as the day of closing of bid.
They have accepted my bid.
Anyway, I'm looking at this. I want to see.
They have accepted my bid. If they have, okay, my lord, on this ground, my lord, they have not rejected my bid. They have awarded a contract, my lord. So that cannot be grounds for bid. Mobilization now, we are allowed to mobilize it on 20th May 25. Then inspection was done on 19th. Then they say now by 26th you have to do it. And on 24th, my lord, they have supplied the bid, which is very essential, my lord, for the purpose of drilling, my lord. The bid has been supplied by them, always, my lord. The drilling bid has been supplied by them.
But your drilling bid was not working. The one that you offered. The one you offered was Dima Asao drilling bid.
No, nothing. I don't, we have to mobilize it on, they given last 120 days, my lord. So on 150 days, we have to mobilize it.
With regard to this TPI,
You know,
the report has to be made with the provision in the contract agreement or in the NIT for submission of TPI. Ah,
if it's not be older than 6 months, as on the date of original bid. Not older than. Maybe, my lord, 10 days. So instead of 23.
okay, it should not be older. Should not be older.
24 July. Carry.
Huh?
24.
24 July. He said 4th July.
24. So page 70. We have start from page 50 of it. Page 70.
Page 74.
Page 70. Last.
72.
Yes. Last. 42.
72. Huh?
Below.
20 report issued on 25th July. Not 20. So your last date of submission of bid was 4th July.
So because, well,
That will not have been my lord. That is not a question, my lord. Here, my lord, they have accepted it. It is not that, my lord, they have not done it. They have awarded the contract. They allowed me to complete.
But then you had offered which rig?
But no, my lord.
It has to be a completed rig.
Yes, my lord.
It has to be a completed rig.
If, my lord, be like it. My lord, it is not that, my lord.
You have to mobilize a completed rig, not a
My lord,
not a incomplete rig.
No, I'm speaking, my lord. It's not shown to them, my lord. It's not shown to them, but this is shown to them, my lord, prior to this also. Because the TDS, my lord, top drive system was not
Okay,
there.
at best we'll issue notice, that's all.
No, my lord, I'm, your losses may just come.
No, I'm issuing notice.
No,
We'll stick to
my
the
lord,
next
your-
day.
No, your losses may just see, my lord, that the TDS was not there. The top drive system, we imported from Japan. Then only,
I don't, that whether you imported or not, I don't.
no, that I have.
We will see on the next day.
No, we have annexed, my lord, that is your losses must. First I have shown that. That I have shown it, my lord.
But we said yes, I have.
My lord, your
And then
lord,
take office.
your losses may just here, my lord.
No more. But with the yes, I will. Learn a senior counsel for the petition. To submit that the notice of termination dated 9/6/25. The impugn letter dated 18/6/25. By which the petitioner's contract has been terminated and he has been asked to vacate the site. The petitioner's case is that pursuant to an e-tender dated 23/5/27, noted by Oil India Limited. The petitioner was awarded the contract on 12/3/2024 for the charter hire of one 2,000 HP drilling rig package for a period of 4 years with an estimated contract value of rupees 222.52 crore. Following the mobilization notice dated 28/3/2020, the petitioner undertook mobilization undertook the mobilization of its resources and equipment, which which met with delays due to circumstances beyond its control. According on the request of the petitioner, the respondent extended the mobilization timeline multiple times till 26/5/2020. The petitioner submits that although the petitioner had completed the mobilization on 26/5/25, the petitioner was instructed to keep the operation in abeyance. Thereafter, a show was notice dated 26/5/25, 8:56. Was issued to the petitioner stating that the stating that as per the third party report, I said CPR, dated 24/7/20, submitted by the petition against the subject contract. The equipment was, the drilling rig was inspected, physically inspected on 3/7/20. And it seemed that the equipment mentioned was actually operating under contract number 6117405 in Dima, Assam during the particular period. Thus, the information provided by the petitioner in the DPI report did not align with the actual practical status of the drilling rig at the time of submission of it and appears to be factory incorrect. The petitioner made a reply to the notice by letter dated 1/6/2025 and stated that in the course of operations of the drilling rig package at Dima, Assam, key items mentioned in the key items were taken out from the idle oil rig at Matua Morad and placed in the drilling rig at Dima, Assam, which was in need of urgent repair. The learned counsel for the petitioner subsisted when the petitioner has mobilized all his equipment within the time limit prescribed by the authority, that is 26, 20, huh?
26 May.
26, 525.
Okay.
26, 525. The petition, the respondent should not have terminated the process. Next part. The Mr. Issue notice. Issue notice returnable in 3 weeks. The case collector accept notice on behalf of all the respondents. 2 weeks. 2 weeks. Mr. K. Kalita, also, petitioner has been saying, has not come to court with reason. It further submit that the petitioner has not mobilized the drilling rig. Is it? Huh? Complete.
Mobilization impact of the rig. Second to equal of rig impact. Mobilization rig
Mobilization has been complete.
but delay of 400 feet.
Delay for it, is it?
Yes, mobilization after delay of 400 feet. They get completed as
Ah.
but the order was issued for review of the production.
Okay. Then the Mr. What was it? Mr. K, he submit that the mobilization by the petitioner is complete. So, however, the contract has been terminated in view of pay.
Case 79.
In view of,
After completion of the rig, they have gone to the
huh?
What
In view of clause 41.0. clause 41.0 of the NIT. What is this? Of the contract agreement. Which states as follows, huh? Page 37. Bottom. This is the matter on
Okay. See the mobilization complete because case 56 mobilization they have to inspect the mobilization status.
Okay, whatever I said. He submits that he does not know if the mobilization is correct.
Status report.
A status report has to be made. This is the matter on when? Yes, yes, that is 14. 14, 15, 16, 15.
After 20, 16.
16. Give a 70, 70, 70.
Only your office may allow that this notice may be at least because they have to interest in that. How the public interest, 18.5 ballot, 18.5 ballot, they have issued that paper ballot for vacating is 5 ballot. At least till then ballot. Because
How can we give a such a stay now?
Hello?
You're praying to stay the termination order. How can we stay the
both
termination?
ballots. We have paid for both.
No, how can we give that as this
Hello?
thing?
No courtesy action will be taken. No courtesy action will be taken. No courtesy action will be taken. Till then, sir, no courtesy.
It's already done, terminated.
No courtesy action.
Huh?
No courtesy action.
On 70. Pressure on 70. They won't do anything. We put this. This also. I don't think. In treatment. Okay, right. Third Mr.
RC.
Asking balance transfer for the applicant to submit that the Commissioner Secretary to Government of Assam, Revenue and Disaster Management, Government and Government, Assam. Commissioner Secretary to Government of Assam, Revenue and Disaster Management Department should be treated as respondent number 6. The prayer the petition, the applicant's counsel is allowed to ensure the period as point number 6. Then you write, application submit a corrected copy of the first title to the registry within 3 days. Then you write in the main field, into the order dated 25, 6, 2025, past WPC 5726 of 2024. Now, for past in IAC 2047 of 2025. So and so is included as respondent number 6. Issue notice to the respondent number 6. Who accepts notice? Secretary. Huh? Revenue. Huh?
Airport, hospital,
For the secretary, huh?
they handle, maybe.
J. Handik, Mr. J. Handik accepts notice of the response. Petitioner shall serve extra copy of the rate petition to Mr. J. Handik during the course of the bill. This is the matter. After 4 weeks, to enable the respondent to file the resident. Right. Matter pertains to payment of contractual fees. Okay, before that, right, no one appears for the petition. Miss P. Data appears for the education department. We can do that. While Ms. RM Baru appears for the point number 4. Anything here? Right. It is noticed that the petitioner, no one has appeared on behalf of the petitioner on the last two court dates. On the last two consecutive court dates. Thus, it appears that the petitioners are interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution. No one appears for the petitioner. And neither have the petitioner filed any reply evidence. This is the matter after the litigation.
Better maybe for the time.
What is the, I know your affidavit basically states that only, that only 10% has been given instead of 25%. So that's the only thing. Yes, you have violated the rules. It appears.
I'm appearing on.
Huh?
I'm appearing on. Time. There's a part of it. I have to take a reply for this one.
Huh?
There's a reply.
No, they might not want to find the, we can dispose it off if the rules are not followed, then what remains? Huh? What is this AMMC?
Upper mind will consider.
Okay, we'll wait for some time. Huh? You see, they're going to, they're going to pass it on. Either we dispose it off or what? Or you want to wait? Depends upon this. Otherwise, they'll keep on. Huh?
I've been informed of the assembly when
Yeah, we'll not do it. Yeah, again. It was not put up. Agenda was not put up. Some reasoning will always be there. You see, you don't need to place you see, you don't place each and every bill in front of a assembly. That is not the role of an assembly. Assembly is to make a budget for a particular department, not for this matter. This is just an excuse. You're trying to, you're either bluffing yourself or you're trying to bluff me also in the process. No, what I'm telling you see, yeah, I'm not saying you, I'm saying your department. When I mean you, I mean your department. Do you mean to say that all contract bills have to pass through the assembly? No. So now you want, now you see, all budget heads are made by whom? Not by the assembly. The budgets are made by the finance department and for the various departments, and then it is passed by the assembly. That's all. So you want to pass a separate budget for him only? Oh, 5 crores.
That's why all together the entire pending amount, like I accepted. We are 23 on the proposal, that's not, but that's the number, right? So, now,
So we dispose it or you go through the right process, do it within a time frame. Yes? End of the matter. Why should we keep it pending? This is just a excuse for delaying the matter. What do you say? You,
again now, that was the last.
this will always happen. Then you always say, oh, they forgot to place it, or there was something, some mistake happened here and there. So that is going to be the normal. I can see it in front of me. The next year, come up next year also probably. Okay, right. Heard Mr. J. Patwari, Learned Counsel for the petition. Also has Mr. A. Chaliha, Learned Counsel for the Finance Department, and Mr. D. Nath, Learned Senior Government Advocate. The case of the petition is that he is a registered class one contractor. It is distinct is para 2 of the order dated 9/8/23. Okay. The affidavit, next para, the affidavit filed by the respondent number 3, that is the additional secretary to the government of Assam, Home and Political Department on 9/12/2024. States that the government of Assam had sanctioned and released funds to the Assam Human Rights Commission for payment to the contractor as follows. ABC, huh? Page 41. Thereafter, what happened? Earlier, 1475 had been there.
Page 44, the last page.
Page 44.
Of that, see that, last page.
Next paragraph. Thereafter, a meeting was held under the chairmanship of the additional chief secretary of our Home and Political Department on 14/8/2024 at 11 a.m. in the conference room of the additional chief secretary, along with senior officers of the Home and Political Department, to discuss the matters cases pertaining to pending liabilities of the political department, where it was decided that SD, what is SD? Whereas supplementary demand / CF, what is CF? Contingency fund proposal amounting to rupees more than 5 crores would be moved to clear the pending liabilities of the contractor, which was under process, and the contingency fund advance proposal had already been submitted to the finance department for making budgetary provision for releasing the outstanding bills of the petition. Huh? 46, 32.
That financial meeting, the medical bill, the basic,
66.
yeah, after that.
Yes.
The WPC number.
Huh?
Page 66, madam. Serial number 1,
Yes.
WPC number 12,
That's correct. The minutes of the meeting held on 14/8/2023 pertaining to the petition states as follows, no? Page 40, page 66 from here to page 67 here. Okay. Next part. So the admitted amount is basically 6.09. Is it?
Yes, ma'am.
But out here it is 581.74.
Yes, by the time educated workshop, like,
But now they are saying for 558, 5.8.
15 of the, I 5.814.
Next part.
Yes, the beginning.
Next part. The above being said, comma, the counsel for the petitioner submit that amount of rupees 5,81,740. No. Amount of, how much is that?
I told 81 lakh 34,000.
Huh?
5,
5,81,74,016
yeah,
is the balance amount required to be released to the petitioner for the works executed by. Pushpa. Next. Mr. Deenat. Learned counsel for the learned senior government advocate submit that the proposal for sanction of the amount payable to the petitioner has been sent to the finance department on 20/05/25, and the same is pending in the final bill. Next part. Mr. A. Chaliha, the learned counsel for the finance department, has submitted letter number BB full stop 55/2025/04 dated 9/6/2025, which states that issued by the Deputy Secretary to the Government of Assam Finance bracket Budget Department, and which is addressed to the Secretary to the Government of Assam Home and Political Department. The said letter is made a part of the record and marked as Annexure Act. The contents of Annexure Act is as follows. From here to here. Next paragraph. As can be seen from Annexure Act, the a proposal for advance from contingency fund. As can be seen from Annexure Act, the political department has been requested to submit a supplementary demand proposal for payment of rupees 581.74 lakh when the next, no, to be placed before the next assembly session. If due to some reason supplementary demand budget does not take place, then a proposal for advance from contingency fund may be submitted for taking necessary action. Full stop. Next paragraph. On considering the fact that the state respondents have admitted that they are liable to pay to the petitioner an amount of rupees 581.74 lakh, comma. This court holds, this court directs all the respondents to ensure that the payment of the admitted amount is made to the petitioner within a period of 4 months from the date of receipt of a certified copy deposit. The writ petitions are accordingly disposed. Huh? Okay, that you want me to add that? Okay, just add, huh? The contract work undertaken by the petitioner for construction of the Assam Human Rights Commission building has been completed, and the said building uh, has been taken over by the Assam Rights Human Commission, and the AHRC is presently functioning on the city.
Yes.
Page 9. The rules are clear.
I can place rules, what it says, that I have to pay 25% as a whole. Of 41 lakhs, I paid 11 lakhs, more than 25%.
Yeah, they said that they have paid only 10 lakh. 10%.
Their documents.
Huh?
No.
That is what he said.
They are saying 10%, and their documents show that I paid 11 lakhs for 45,000. That is a page, your lordship will find a page 14. Page 14 is 41 lakhs, and my deposit is at page, your lordship will find at page 8.
No, let me, what is this work? This is a mining permit for what period?
For 7 years.
For 7.
From which year?
My lord, it was from 2013 to 17.
Then 20, then finish.
My lord, now the impugn order which has come, and not for mining, the impugn order has come because in the meantime, somebody has filed a petition and that they have offered a stay order. So I was not given the option to do mining. Then that petition was dismissed in 18. Then we should have impugn order saying that as per 37.5, you have to, you have not been able to deposit at 15%. So
25%.
25%. But my amount is, your lordship will find at page 17. Page 17 is on receipt from amount of 11 lakhs, being 10%.
Okay, what is the amount? Let us see.
41 lakhs, 50 rupees.
What was your bid amount?
Bid amount is 41 lakhs 50 rupees for a year. Annual
41 lakh
50. 10% is 10 lakhs 25,012. 25%. I have deposited 11 lakhs. And page 18, you will actually find Divisional Forest Officer rights to land.
What was the bid amount submitted by you?
My lord, up to the bid amount, it was given to me on page 14. Subject to having provision such and such Golopets being a successful bidder of the company being invited to public notice for getting the mining contract to grant mineral concession in respect of such and such for 7 years of annual quantity of 4,000 and offered annual price of 41 lakhs. So that is at page 14.
And you deposited 11 lakhs.
11 lakhs, that is at page 19, 18. And that was in 2014, 6/3/2014. And my lord, the writ petition order has come upon by an interim order ex parte on 13/8/2014.
So right now, there's no mining going on.
Not mining going on, Malad, they have issued an appeal order which is paid by this court, that is at page 24.
So how much is the amount he has paid? Look, we have not given the amount.
We have not given them a
Then you please give an amount, how much he has
how
paid?
much he has paid.
Yes, what is the bid amount? Now, according to him, the bid amount is 41 lakh 50 rupees. So if that is then it appears that 10 lakhs will suffice. And according to you, you have paid how much?
11 lakhs. 11 lakhs 61,680. It is their document which shows that
61,000.
61,680. 11 lakhs 61,680.
11,61,000 roughly means the 10% initial bid security, 1 month annual contract money, and 10% additional amount. And combining that three, this 11.
Okay. No. So 11. So this 11 lakh is earnest money.
Is
Earnest
it-
money.
At page 80, if I watch the report,
Page?
page 80. Page 18, you're watching.
To the director.
Yes, sir. Okay.
As the
But-
performance of now it is 41. Now the 4 years for the minus deposit 10%. He has deposited, it's fine.
This month. At 10% initial bid security. So it's 1 month annual contract money and 10% additional amount of after fund.
So the entire money is not the bid money. So one is the security deposit will be different.
Malad, is for the, that is why I'm asking, Malad, let me find rejoinder to their affidavit. They have filed after 5 years. Malad, the lead petition is of 2019 and they have filed on May 25.
Okay, right. Mr. P.K. Roy Chowdhury, office for the petitioner is granted 3 weeks time to file affidavit in reply to the affidavit filed by this point number 6. The petitioner's case is that he had been awarded settlement of the Daboka Ordinary Sand Mining number 1. Pursuant to letter of intent dated 18/1/2020, 2014, 18/1/2014. For an amount of rupees 41,00,050. The petitioner having submitted rupees 11,61,680. The petitioner submit that the petitioner's settlement of the mining rights could not have been terminated, legally terminated. No, not terminated, could not have been, the petitioner could not have been, uh, stopped from mining the said area. Next paragraph. The affidavit of the point number 3, on the other hand, submits that the petitioner had deposited 10% of the annual bid amount and submitted 10% of the annual bid amount as initial bid security. Let us see this AMC rule.
Fine. The rule says first 10%, then 15%. you looks into Rule 3, it describes about the process of completion of the various stages of payment. And first is, total is, no bid shall be regarded as successful unless the obstacle of the successor. The highest bidder shall be required to deposit an amount equal to 25%. Total amount is 25%. Rule 2, 37.2. And 37.3 says the completion of various steps. First is 10%. Next, 13.5, what they are claiming is 15%. And total I have 55%.
What does the NIT say? There is the NIT. There is the NIT.
NIT is not there. But I was sitting through a protection, I was giving a settlement.
You are settled through a NIT?
NIT is the, you can talk about it.
Then I think you have to bring the NIT. Bring the NIT. We'll see that. You bring the NIT in the next day. We'll fix the date. Huh? Right. Whatever I said. States that as per Rule 37 bracket 2 of the Assam Minor Mineral Concession Rule 2013, the highest bidder is required to deposit an amount equal to 25% of the annual dead rent / contract money as security, along with an additional amount equal to 1 month dead rent contract money in advance. As per the LOI, the petitioner was to deposit 10% as initial bid security. Anyone is mining now? Anyone is mining the area?
That is what's happening.
You find out. The stand of the respondent is that the petitioner has submitted only 10% of the bid money and has not submitted the balance 15%. Mr. R.R. Gogoi shall submit an additional affidavit stating the amount submitted by the petitioner on account of for initial bid security and the exact amount submitted by him for the annual dead rent / contract money. The petitioner, Mr. R. Roy can also produce the petitioner and the respondent and Mr. R. Roy shall produce the note NIT on the next day. This is the matter on liberty. Mr. R. Roy shall also obtain instructions as to whether any mining activity is ongoing in the mining area. Okay.
Instruction is the Assam House, something supposed to be like that. Instruction is supposed to come from.
Quarter time till 20th of July. There was a meeting. That's how I was. Me of the meeting. So some report has come from the legal department.
Correct. Mr. B. Roy submits that the meeting was held with regard to the contractual dues payable to the particular, and a report has been made by the PWD, which the respondents would like to scrutinize. He accordingly feels that the matter be listed on 20th July. 21st July. This is the matter on 21st July. Okay. No, no, doesn't matter. We didn't want any of you all to be here. No, actually, it is in the afternoon. Well, we thought, instead of wasting another day. Yes, not only that, even for this court to keep it pending for another day becomes a problem. Yes, item 12 and 13. Yes, madam.
Instruction
Oh, very good.
morning. Yeah, what?
For two cases,
For 12.
for 12. So you need time.
Yes.
Okay, Miss P. Say appearing on behalf of Mr.
RM dust.
R.M. Das, that is counsel for the Water Resource Department, submit that para-wise comments have been received. Accordingly, affidavit will be filed within 3 weeks. This is a matter of the 13th, para-wise comments, okay. Mr. K. Gogoy, huh? Okay, instead of K, say Mr. K. Gogoy. Same date.
If you make it, make it.
Oh, no hurry. Give it. No hurry. Actually, your contract will use this for which period? No, I just want to ask him. 23.
Much obliged.
Yes, that committee report not supplied. So then, if committee report not supplied, then we set aside the thing. We set aside the blacklisting order. And in the meantime, if we give you liberty, you can issue him a fresh notice if you want. That's the only way. Correct? Correct. Alright, Mr. A. Dagadu, other senior counsel, assisted by Mr. A. Dag, huh? Also heard Mr. M. Katif, counsel for the, huh? For the, the petitioners, the petitioner is agreed with the order dated 22/10/2024. Issued by the respondent number 8/2/20. 8/50.
That 50.
Okay. Then you are, then if you are. Okay,
56. Equally, the blacklisting order was issued. That order was set aside. Thereafter, another super.
okay.
There's another super.
Okay.
This outlet.
Okay, okay, that earlier blacklisting order was set aside. Which order dated
8 February 20.
Order dated 8/2/2025, issued by the respondent number.
District Commissioner.
Who is he? Respondent? Not a party. Yes, he's not a party.
Yes, Commissioner. Now, two.
Come to the top of page 56.
Divisional officer.
Correct.
Order was issued by Divisional District Commissioner. So, Additional District Commissioner is Deputy District Commissioner in that part. There is respond much.
This order has been issued by the office of the LCO,
Here, order was issued by the.
LCO Civil, office of the LCO Civil. But additional district commissioner is never LCO Civil, it's above LCO Civil.
No, I don't.
How come this?
Oh.
I- Your officers are doing, what are they doing? And you also, you have not made him a party, the detail district commissioner.
Yes, no, subdivision officer made a part.
So what?
SDO.
SDO may be made a party, but additional district commissioner is never SDO, he's above SDO. He's above SDO, SDO civil is below additional DC.
SDO speaker has been made a part.
Additional DC and DC are same. It's like, it's like being a permanent judge, additional judge, like that only. The same. Anyway. Should have they made them a party at least.
SDO has been made a party, and District Commissioner Kian was also made. Both are made party, 2 and 3.
I can understand if DC was, if the letterhead was DC's office, then the additional DC assigned that okay. But letterhead is of SDO's office. And additional DC assigned.
SDO has been made a party.
Okay, right. So that's it. Additional district commissioner is charged DC. By which the petitioner has been blacklisted for a period of 3 years. So, next time. The petitioner sought the petitioner sought the no, this don't say the thing. The petitioner's case is that. Just a minute. Page 50, para 2 and 3. Huh? Wait. Being agreed with the order dated 22/10/24, 22/10/22, by which the petitioner's firm was blacklisted. The petitioner challenged the same by WPC number. Where you have not put. Yeah, page 50, where is the page 50? Come to page 50. Where is the page prior to page 50? WPC number, party's name, nothing is here. PLR saving. We don't know whether this case pertains to this. They're attending. Which page?
Case 127.
Huh?
Case 127.
What to see? Your juniors needs to be hauled up. File WPC 5973 of 2020. This court. Dispose of WPC 5973 of 2022. By order dated 30/1/2022. By setting aside the blacklisting order dated 22/10/2024. On the ground that the show cause notice dated on the ground that no show cause notice has been served upon the petitioner prior to the issuance of the blacklisting order. Next time. Subsequent to the above fact, the petitioner was served with show cause notice dated 5/3, no, 1/2/2025. Page 56. Page 56. Wherein it was stated that the petitioner had submitted bills which were highly inflated. A committee was thus formed to scrutinize the bill of the petitioner. And the committee thereafter found that the petitioner had intentionally tried to this is the one. Yes. So where is the report of the committee? This is the one. It was not funny. I know. So where is the report? Where is the finding? Huh? No, I know. I want to know what is the report of the committee. I've got it here. This is the one. Yes. You got to Manas.
Yes, Manas.
Yes, but what does it say?
See.
There is nothing here. There is nothing. There is no, there is, huh? But then in your show call, you have given a lot. You have said that committee is of the view that so and so had intentionally tried to do this and that. But this is not reflected here. That From where did you make these words? The committee upon minute scrutiny observed that the bills were found to be highly exaggerated and significantly higher. But nothing has been said here. What about this? Just read from the beginning of the paragraph. The 1 to 2025, stating that, just read. Try to cause loss or misuse of public money. And that his bills were significantly higher than the demanded quantities as per the work order. Next slide. Let's see the next slide. The petitioners also published that the petitioner made a reply dated 4/5/2025 to the show cause notice dated 1/2/2025, wherein he stated that he was not aware of the formation of the committee who had scrutinized the petitioner's bill, and that he had not been informed of the rates available. He is not informed of the available and panel rate. Further, there was no technical person present, and neither was the petitioner provided with the market rate. Is it? No, no, and not, and that the petitioner provided the market rate as per standard term. However, the issued order dated 8/2/2025 was issued blacklisting the petitioner. On the ground that the petitioner had submitted bills at higher rates than the panel rate, which was a clear violation of the terms and conditions of the. Next slide. Mr. M. Tete, that is counsel for the, all the counsel. 2 to 4. 2 to 4. As submitted. The committee, the report of the committee constituted by the state respondent to verify the bills of the petition. He, Mr. M. Tete, submitted that the petitioner was not provided a copy of the committee report along with the show cause notice dated 1/2/2020 to enable the petitioner to have made any representation against the committee. I have heard the learned counsel for them. The only question to be decided is whether the petitioner has been given a fair chance to be heard with all the required particulars which the respondent was considering for proposing to take, before issuing, before proposing to take the action of blacklisting against the petitioner. Next slide. In the case of Eurasian Equipment and Chemicals Limited versus State of West Bengal and other, reported in 1975, 1 and 57, the Supreme Court has held that the principles of natural justice have to be complied with, and the tenderer who is thought to be blacklisted is required to be put on notice as regards the allegation made against. Next one. In the case of Gorkha Security Services versus Government LCT of Delhi and others, reported in 2014, 9 STC 105. The Supreme Court has held that in order to fulfill the requirements of the principles of natural justice in matters relating to the proposal to put a person or a firm under blacklisting, no, to blacklist the firm, to blacklist the individual or firm, comma, a show cause notice would require to meet the following two requirements. Number 1 and 2, simply that para 22 is there. All right. In the present case, the show cause notice, what does that mean?
1 to 2025.
Huh?
1st February 2025. Page number 54.
The show cause notice dated 1/2/2025. Shows that the show cause notice has been issued on the basis of the scrutiny of the petitioner's bill made by the committee constituted by the response. Further, no, however, the said committee report has not been issued to the petitioner along with the show cause notice dated 1/2/2020. Correct? Huh? This is clear from letter number BJEL 23/2024 466 dated 23/6/2025 issued by the additional district commissioner beginning to Ms. Yu Das, additional senior government advocate. The said letter dated 23/6/2020 issued by the additional district commissioner which made a part of the record and master. Huh? Next. The other issue, no, the other thing that caught the attention of this court is the fact that no, that's all, no need. Next. The petitioner in his reply dated 7/2/2025. No, no, 5/2/20, 7/2/5, you've got 2 days. Make it 7 to 27. Earlier case also it was the same. As specifically stated that he was not aware of the formation of a committee to scrutinize the bill. And that he was not informed about the presence of any technical person for the same. Further, the petitioner provided market rates as per standard practice. For rates not available in the end panel rate. So, next panel. As has been held by the Supreme Court in the case of Duration Equipment Limited as the Super and Gorkha Security Services. Company. The petitioner was to be given the statement of imputation detailing the alleged breaches and defaults he had committed. The materials and grounds which were to be taken into consideration by the respondent had to also be furnished to the petitioner to enable him to make a proper reply to the imputations made against. In the present case, the show cause notice and the action of blacklisting the petitioner having been made on the basis of the committee report. It was incumbent on the respondent to have issued a copy of the committee report to the petitioner prior to taking a decision. No, to enable the petitioner to reply to the committee report. On a bare perusal of the committee report, this court finds that the only thing that has been stated against the petitioner is as follows. Right? You got command 6 full stop Manas Enterprise dot. The bill submitted by Manas Enterprise was carefully scrutinized. And the following adjustments were made as per the observation in the The above being said, the observations made. No, the observations attributed to the committee, as reflected in the show cause notice dated 1/2/2025, is not present in the committee report pertaining to the petition. In any event, be that as it may, this court is of the view that as the committee report has not been furnished to the petition, along with the show cause notice prior to taking a decision to blacklist it, the order of blacklisting is not sustainable. Order of blacklisting the petition is not sustainable. Accordingly, the blacklisting order dated 8 to 2025 is hereby set. That's all. I will not give you liberty that there's nothing, that observation from where did it come? I don't know. Verified accordingly allowed.
Should I? What is that?
Yes.
Yes. My lord, last order, your lordship may kindly see, my lord. All my prayer is that, my lord, the petitioner is L1 in some of the districts, my lord. He should not be disturbed, my lord. He should not be disturbed by a tender notice dated 23/5/25. I have given an additional affidavit showing. Mute. Unmute, okay. Like showing, my lord, the petitioner has also participated in 5 other districts and became L1. So in view of the last order, I pray, my lord, the subsequent notice should not disturb the petitioner without notice, my lord. Because in view of the he is becoming L1, my lord, he has purchased substantial quantity of tarpaulin, and district authority should not be disturbed, my lord. They have purchased. The state authority have also, my lord, floated the tender.
So this is for what? For the districts also? For what?
Additional affidavit filed by the senior. I think earlier, but that the work order has been issued. I think it is not affected.
But the work order has been issued.
Work order, some of them are that.
No, he says that for this Rahat, 4 districts that has been issued, but for Darang and Nagong it is not issued.
So,
Has it been issued? Huh? Yes.
File and one additional affidavit.
What is the additional affidavit about?
Additional affidavit shows, my lord, in 5 other districts have also issued NIT, and in that 5 districts, my lord, the petitioner is L1. L1. So in one district he got supply order, in district of Morigao. So my prayer is, my lord, let government file affidavit, but in the meantime, my lord, petitioner selection as L1 bidder not be disturbed, my lord.
No, how is that? How is that? This is for the state.
For the state,
They are going to fix the rate.
no,
The
no,
rates of
my lord,
supply, correct?
rates have already been fixed on the basis of the NIT and on the basis of the comparative, my lord, prices. Rates have already been fixed. These NITs were issued by the district authorities in the month of February and March. Now, in the month of May, my lord, 2025, my lord, the state authorities have issued NIT only in respect of the tarpaulin, my lord. So, what they have not cancelled my tender and not my selection. So let them file affidavit. Till date they have not disturbed me. Till date they have not disturbed
I
me.
don't know.
I'm
This is all for the benefit of the state. How it this is all for the
No,
benefit
on
of the state.
on the
It's a
basis of
question
the
of supply.
on the basis of the earlier NIT, the petitioner was selected
Yes,
and he became
what
L1.
is the instruction?
Paragraph 8 was the
Let them file the affidavit, my lord.
that rate.
Huh?
The rate.
Or rate variation, lot of variations.
I look at the rate. I look at some of the districts. I look at rate is 468. Someone is 666. And some districts pilot it is 47.
Well, let them file the affidavit.
Like
So his rate is good. For Nagong is 468. Darang is his also.
in the additional affidavit, he annex one order copy notice that is page 148.
Supply order. That is 520, yes.
148, yes. So what about 148?
That is a supply order already given by Borpata, Morigao district.
Number of quality, given the 500 rupees, 520.
Wow.
So there is a variation of the rate.
Correct.
My lord, variation, your lordship will kindly see this variation. First, your lordship will kindly see the NIT at page 31, my lord. 28.
No, you see,
It starts.
no, so this is for Morrigan 520.
Yes.
This is
It depends
too high,
upon distance, my
correct?
lord. No,
Why
it
should there be
depends.
such a huge variation?
No, my lord, it is because of the distance.
Huh?
Distance, because we are required
There's
to.
hardly any distance between. There's hardly any distance between all the districts.
My lord, your lordship will kindly see page 28. page 28.
This is all
Do
for,
it.
this is all for the public interest, for the public money has to be saved.
No, no,
It's
not,
it's
not,
not for making you rich.
no,
It's for
it is,
public.
I'm not denying that, my lord. What I'm saying is that your lordship will kindly see page 28.
Huh?
28. Page 28 of the writ petition. I'm just showing as an example. For all these items, rice, sugar, gur, mustard dals, then my item becomes at page 24, tarpaulin. All these items in all different districts, the rates are different. In all, but they have chosen only tarpaulin.
No, you
And
see,
they have issued.
because tarpaulin is made by a particular company. So they want the fixed rate. There cannot be much of a difference. There cannot be 100 rupees difference or a 50
But this
rupees
will
difference.
amount to, this will amount to, my lord, cancellation of my selection
Maybe,
without
maybe.
any notice.
Maybe.
Without any. So what I pray, my lord, let them give the affidavit.
Let them
Whatever
file
they
the
want to
affidavit.
give. Let them file the affidavit. In the
Yes,
meantime, my
Mr.
lord,
J,
my,
will hand it that passport for the. For the 1, 2 and 3. 1, 2 and 3. And Mr. M. Chetia for. So shall file the affidavit within 2 weeks. Please the matter. You will.
my lord, what I, subject to your, what your
No,
lordship may
because
say.
no,
No.
not during flood season.
No. What I, no, flood season, they are going to get the items. What I am saying, my selection should not be set aside, my lord, without hearing me. This is my prayer, my lord, or without any notice to me. I have been selected, my lord. And accordingly,
Nothing is being done.
no, I have gathered 30,000 tarpaulin for the purpose of meeting the urgent demand. So I have already purchased 30,000. I put it in my affidavit.
There is
Because
no
they are,
water. Why did you do it?
because the condition is such, my lord, your lordship will kindly see the condition is that you will have to supply immediately from the even telephonic order.
Maybe.
Even telephonic order, my lord.
We'll see. Yes.
My lord, my prayer may be
Well,
considered, my lord. They should not disturb my selection, my lord.
I took it is section. Mr. And the budget 11,000 for the orders number 1 to 4 is granted. 3 weeks time to file affidavit in the position. Interim order passed ready to continue till the next week. Item. Is this matter infructuous? Huh? 17 matter. Who is the counsel?
Miss Kunduli Dev.
Huh?
Miss Kunduli Dev.
I will dismiss it for default. If you say that. You see, the matter pertains to a contract. That has been awarded to the respondent number 4 in 2014. 17. Why don't you obtain instructions whether it is completed or not, the work? It will be completed at, I think, 8 years have gone. Can you call the PWD officer?
Otherwise, let us call this, they are not responding. Then we'll call them. Okay, right, we'll call the commissioner.
No, madam. Yeah, I will. But they,
Call him now. Otherwise, I'm calling this commissioner. to come. Item? Why?
The settlement order was not
Up to 21. Okay, right, Mr. 80,000, I'm asking for the petition. Submit as a matter is coming from this. Mr. P. Sharma appears for the AFDC. The writ petition is accordingly dismissed. Service. We'll leave this matter tomorrow. Jal Shakti matter. Okay, right. This matter pertains to claim for compensation amounting to rupees. Let us see how much is prayer. Claim for contractual dues. How much are you claiming? This is a contempt. No. How much are you claiming? Okay, anyway, just right. Mr. R. Deca, Senate Council for the response subject. That the petitioner has been paid rupees 15, 14, 555. And balance is rupees 32, 18, 430. The review. Before whom? Concerned court. Review is dismissed. But this I cannot take. This is a contempt. Okay, Ms. R. Data submits the affidavit will be filed on behalf of the respondent. Huh? Mr. Council, this is a contempt. This is not a writ petition. Sorry. This is a matter of the beginning. Okay. Give a date. All right. You're not taking steps.
My instruction is already closed at this stage. But some petition is already filed.
In respect of the same issue. Okay, Mr. P. Barwan and counsel for the petitioner submit letter. Contempt petition can be closed. As the subject matter is the issue. Has been agitated in WPC number 853/2020. 853 of 2025. So, the petition accordingly closed.
last order.
Yes,
It's the. Also having a lot of.
and so then who is this Rakibuddin? Huh? Who is respondent number 3? His name is Rakibul Zaman Chaudhary. No? Then? And then this Rakibuddin is different. Huh? So Rakibuddin has expired. And Rakibuddin is also known as Rakibuz Zaman Chaudhary. So what is to be done now? Huh? So who is the person who is to be substitute? Who is to substitute respondent number 30? But who are the legal representatives? Unless he knows who to lead. Has he given anything to you?
No, just one death certificate is given.
Is his wife's name there? His children's names are there?
Yes, next up,
Oh, that's a picture. Is he in that?
Why the doctor's name?
Then include the right. Mr. Hemanta Gogoi. No. What is the name? Mr. S. Das. Appearing for the private respondent. Submits that the respondent number 13 has expired. And he has given a copy of the death certificate along with the next of kin certificate of the respondent number 13 to the petitioner's counsel. The petitioner's counsel accordingly pays for time to file an application for substitution of the respondent number 13. This is the matter after the appeal. No, not 7. The 17 is not too many matters. 5th August. It has been submitted that the matter can be listed for hearing. Accordingly, this matter on 5th August.
The Lordship, on the last occasion, they could time to file the
I have 14 section. The department is that the here what is directed to state. The department has already got paper proposal from the deputy secretary for an amount of 10 lakh 70,000. That was the university. And for the rest of the amount, they are relating to the
The Lordship, my client, that is the petitioner, is suffering from financial stress. And according to the long pending outstanding, debt was amounting to 20 lakhs 16,587. And accordingly, an affidavit of opposition was also filed by the respondent authority. And equating the liability to the full of these 15 lakhs.
that is the direction of the honorable. Pay the thing like. But out of the 15 lakhs rupees, we now as of today, we have only 10 lakh 78,000. Proposal has been
Proposal has been sent to whom?
to the department, transformation and development. To the secretary to be given to the department. I have already clarified. And I have processed the thing. They should be paid and then the 40 days.
When will they pay? The issue is, you see, we want the payment. We don't want when after 20 years. We want it now.
No, already the department has clarified this much of amount that come to the director to be paid something.
Page, that is that I like you to elaborate on that word shortly.
Exactly.
You think exactly.
Petitioner person, it is, that is.
It has been a long time, the Lordship.
That is the difference. Consider considerable I received it from.
And the order passed by this court was in 2024.
That's true. I hear.
So when will they pay? I don't know why do they have to file contempt all the time? Why don't they do it, or why don't they obey the orders of the court in the first instance? As if,
They have sent the record and the verified team vouchers for this amount they have already given. Total is 10 lakh 28 to the 220. This not fair in the particular. This amount they have given.
look, now you are saying no record, but when the order was passed by this court, they all have taken a stand that you are liable to pay the said amount of 15 lakh. You have admitted this. Now you are taking a different stand that no records are found. Or
We are not behind it.
why do you wait for a contempt to be filed to do all this? Why is it not enough for you all to take action on the basis of a decision passed in the writ petition?
And the lordship, even reminder was also given to them.
Just a minute.
on second. Right.
You are fanning the flame.
Without,
It's okay. I think you should pay by July. It's 10 lakhs whatever. This is an admitted amount. It's not a question of verification. Because on your admission that has been made. No, Mr. Council, you see, all funds are usually already there when someone is asked to do certain work. Now, just because the work order is to be issued by the DC does not mean that they can escape their liability, the persons with the money. When they have delegated the power of giving the work order to the DC, they cannot say, okay, he can give the power to delegate, to issue the work order, but payment we will do it when it pleases us. DC has examined, said everything is order, pay. Who are you to keep the money with yourself? Financial norms are there, but then so many cases are there, I don't have to repeat each and every time. All of it. Only problem is your shortly is measured sometimes in years. That's the problem.
the lordship kindly fix,
We'll fix the date. And if they do not do, then we'll call them. Right. Naturally. Mr. Dina, let us transfer for the response submit that though the admitted amount of rupees 15 lakhs is to be paid to the petitioner, as the same had been admitted by the respondent in the writ petition. Now, during the proceedings of the writ petition, the petitioner secretary to the government of Assam, trans, trans, Transformation and Development Department, has issued a letter dated 24/6/2025, stating that the District Commissioner Demaji has submitted a proposal for rupees 10,78,220, along with documentary evidence with certification of bills and vouchers, which is already processed for payment. This matter on that 1st August, on which date it is it is hoped that the payment of the above amount is made to the petitioner. This is the matter. Perfect.
Thank you, Akshay.
I've mentioned this.
Yesterday.
Capping week.
Yes, yes, same contract.
Yes, we are.
Audit class, for this period also have become in problem.
Whatever you think about actual it's on 25 of July. Okay, right. On the 1st, the party list the matter of 23rd. Along with WPC number 3375 of 2025. Item? Maybe. On the last day, you had said that instructions have been received. And you'll be filing within 3 weeks. Then why? What is the problem?
Actually, there was some election. We have received the select now. We wanted to file. We did this week.
Are you filing anything, Mr. Bora?
That part of it. That part of it. That we filed it. So we want to all direct one. So basically,
This time we have submits that he could not file the affidavit as the instruction received by him did not contain the annexures. However, the annexures are now with him and he will be filing the affidavit within this week. He'll come after, but when will you file? Within this week. This is the matter. Okay, you are it. Okay, you also write Mr. S. Bora submits that he will be filing his affidavit after filing of the affidavit by the PW. That is fine.
Taken back the people are they comfortable? They're not sure. Other than
Where are they? They were in Tripura yesterday. Huh?
I have to but
They were in Tripura. They bad because of bad weather. They landed in Tripura.
I have to they're expecting this.
Good. It shows the conduct of the applicant. But what about YS Manan, S Hawk, MD Indrani? They are all there. This is only by S.H. Kizar. You had appeared yesterday also.
No.
Huh? Samaja Council. Okay, right. Mr.
Ajit.
R.J. Sharma. No. I want them to let it be here. I want them to come. How does it? There's no stay on them. Their order is still standing. I want them to come. Let us see what twists and turns they will do. I'm going to write down. Right. Heard Mr. Sesson, let counsel appearing on behalf of Mr. S.H. Tikdar. Petitioner? Applicant, you mean? to submit that. The applicant approached you directly. When the Vakaratnama, so you will be appearing for the applicant. Oh, very good. Huh? No. Submit that you will be appearing on behalf of the applicant. Applicant, in as much as he has been informed by email that he is to be engaged. So he submits that Vakaratnama will be filed within 2 weeks. Uttar. He also submits that the earlier counsel for the applicant, Mr. H. Tikdar, has submitted a certificate dated 24/6/2025, stating that he had returned the brief of the applicant to the applicant on their request. Further, he had no objection if Mr. R.J. Sharma appeared on behalf of the applicant. Next paragraph. This application had been listed today in view of the fact that the counsel that had appeared for the applicant had appeared for the applicant yesterday, that is on 24/6/2025, had stated that the applicant were on their way to Guwahati to sign the form for opening a joint venture account. The counsel for the applicant had stated that the applicant's plane could not land in Guwahati due to bad weather and that the applicant had to land in Tripura, in Agartala. That was the further. The applicant would thereafter come to Guwahati from Agartala. However, it appears that the applicant has not landed in Guwahati, and neither is he appearing in the court today, despite the submission of the counsel for the applicant who had appeared yesterday in the court. The prayer of the applicant in the writ petition is to clarify as to whether, as to when, as to the date from which the bills done by the joint venture would be deposited in the joint venture. Next. Next paragraph. Mr. R. Sharma appearing for the writ petitioner. Respondent number, / respondent number. I know, out here in this application. And appearing for the writ petitioner had brought the forms for filling up, had brought 3 forms for making a joint venture account pertaining to 3 banks, some of which had been signed by the writ petition. The only requirement was the signature of the applicant for opening the joint venture account, which had been agreed to by the applicant.
Applicant and the other part.
And the other party that is ALTIL. The applicant, next, in view of the prayer for adjournment made by the counsel for the applicant, list the matter on when give a date, initial opening. 16/7/2025. On that date, the applicant should also appear personally before this court, along with a representative of Altis, who is authorized to open who is authorized to give sign the application form for opening a joint venture account on behalf of Altis. Item? This is parawise comment. This court had asked him to produce two documents. One is the termination letter and the show cause notice. Where is that?
Our lordship, in that one of paper, the termination letter is there. What is the last thing?
Only forwarding of the letter.
Yes, my lord, there it is written.
Then what is written?
In view of the above, it is decided for the sake of public interest.
Where? I don't, it said last letter is
23/9/2016.
oh, I was speak there. Right. Oh, that is second last letter, not last. Okay.
The third paragraph. In view of the above, it is decided for the sake of public interest to terminate the work from your custody by forfeiting your security deposit, etc., and accordingly get the work done according to my other activities.
And where is the show cause notice? If it has been issued, not issued, no. Because of his, he had requested.
Yes, no, and earlier also there was correspondence to complete the work. Thereafter only we requested,
The letter, your letter is of 3/10/16.
Yes.
After termination of the contract. What do you mean? Huh? So? So? How does it matter? You have been terminated, your contract has been terminated prior to you informing them of your illness. Yes, what is the judgment you relied upon? Page 22. Yes. You see, this, uh, this judgment is different of fact. It's different. Out here, the contractor had informed the PWD that he was ill prior to the termination. Let us see what is the case of the person. You file an affidavit. Okay. What is it? Affidavit of position filed by respondent number 3. Who's respondent number 3? Chief engineer. You have not submitted this along with your affidavit. But file this. Submit that you would like to file an additional affidavit. incorporating various documents to show that the petitioner has been defaulting in his own schedule. And numerous requests have been made to the petitioner to continue to do his contract. The pair of the petitioner, pair of Mr. P. Chaudhary is allowed, is the matter after 3 weeks to enable him to file the petition. I can dispose it of, but if I need to on the record. After tomorrow, no, you will let the commissioner come. It's the RC. RC. That is our property. No one appears for the PW. So Mr. M. Katia appears for the, huh? Who appears? For whom? No, you ask them whether this contract is effective. Because I'm calling him. By Friday. You can come on Friday also by calling him. You feel you call them by phone now. Ask them whether this matter become a call them, I'll keep it. Then you can come and tell me in my chamber. Item? Yes, what to do?
I have filed
The pair the parties is the matter. On Tuesday. Huh? Fair to participate. In the month of when? So long back means what? Last month? Last month was long back. Well, you all are the ones who are asking for adjournment. Huh? On the prepare for adjournment made by the fund number 3, 4, and 5. Who is 3, 4, and 5? Three, four, and five. This is the matter. What date did you give?
Can I be on my road?
No. Those months are, those dates are we are full. Well, how many cases we have picked on those days? The court, you see, you are not the only case in the world. Please understand, and your case is not heaven will fall. There are 20,000 other cases where heaven will fall. There are already 52,000 cases in this court. So yours is one of the 52,000 cases. Give a date. Yes. Still. Interim to date. what to do? Even, huh? Yes, you get the information. This is a 2017 matter. You should have instructions by now. Because otherwise, if you don't have plain instructions, keeping it pending just like that. If it is not instructions, well and good, we'll adjourn. But if it is instructions, why keep it pending? At least get some information. Contract work, construction, small piece of road, 2017, cannot be, I think it must be overtime. You see, another thing I want to understand that we are in a hurry to do cases at times, but then the problem is we are also have to pass orders. That takes a lot of time. It's not so easy. What you're like the other day I had a bail matter. They finished the argument, I think, 15 minutes, 20 minutes, but my order had to run to around 26 pages. That is the problem. We are also hard up for time. But the other ways, if we could dispose easy without much reasoning, then no problem. But then we have to give reasons, we have to justify. We have got to understand this side of the problem, not only your side. As you all know, that the amount of judges in India is very less, and the workload is very high. I don't know whether you all know how much hard work you also do. Like you all do, you also do. So this is